Unakhampo Islamic law and secular law. The term secular law may not be very apt. Some people may wish to call the existing law, which is based on the common law or custom, as a customary law in order to give it greater validity. We have said in what has preceded that norms of the law represent the collective conscience of the people. This may be true of Islamic law, but may not be true of the entire law obtaining in Pakistan in any case. Islamic law is that law which is based on the injunctions of the Quran and Sunnah in accordance to the constitutional requirement. In some cases, this law has independent rules of evidence and procedure. One thing is not clear as to whether existing law that has been subject to the repugnancy test by the Council of Islamic Ideology or the Federal Sharia Code may be called Islamic when nothing conflict with the Islamic injunction has been found. This would mean that the existing law not found repugnant represented the collective concerns of the Muslim community. We feel that each law must be restated in new terms so as to verify the operations of the collective sense of this community. There are the other areas of the law that may be classified separately. These are the constitutional law and administrative law, municipal and international law. It is also to be noted that the term civil law is applied to mean the legal system applied in most European countries, as well as those countries that follow this system, including the certain Muslim countries. It is used to distant from the English common law. International law and the authority of law. The meaning international law is a law and the authority of law are discussed below. International law is a law. There has been considerable debate as to whether international law is a really law. Different views have been advanced in the past. Some have maintained that it is a law as that there is both legislation and law enforcement in international law. Legislation is through the multilateral treaties and sanctioned by the help of self-help and war. Otherwise, like Open defined international law as a body of rules for human conduct within the community, which by common concept of this community shall be enforced by external power. It is true that international law, especially the convention and declarations of the United Nations, is gaining increasing importance. In many countries, a convention signed by the country becomes law of the land upon ratification. In Pakistan, this is not the case unless statutes are made to implement it. But many conventions ratified by the country are leading to law reform. Notable areas are the rights of women, labor and children. In fact, these are several theories about the natures of international law. To understand the issue fully, see the section on the treaties and consequent agreement in the chapter on legislation. The acceptance of international law is a binding law. Raises the issues of the source of its binding force. The authority of law. Salman lists two main sources and then points out the weakness in these assertions. The binding natures of international law comes from natural law. Natural law, according to Salman, is nothing more than morality. Another idea is that the binding nature of international law and the consent of the state. The rules are binding because states have agreed to be bound. It is suggested that discussion Salman book is a bit dated. Once again, to appreciate this issue, see the section on treaties and consequent agreement, especially theories of dualism, monism, and so on. Law is in order of norms. The idea of law is the structures of norms has been given great importance by the writers. The reason is that norms are the common element between all types of laws mentioned above. Norms are the basic element in the atomic structures of the law. Bonnemer, for example, organized his book around a synthesis between order and justice. In doing so, he elaborates that at length the meaning of norms are used within the legal system. The meaning is summarized below. The term norm is derived from the Latin word norma, which means rule, standard, yardstick. It is the hallmark of norm in the sense in which this notation is relevant to the logical process. That it contains generalized pronouncement of directive which authorize, prescribe, prohibit, regulate human action and conduct. The customary use of term does not include a purely individualist and ad hoc dispositions of single particular situation. Types of norms. Norms used by the legal system in guiding private and official conduct are of consider variety. They may appear in the following form: in the form of rules. This is the most typical form. Rules may be prescribed in the moods of normative control characterized by a substantial degree of the precision, concreteness, and definiteness. A ruler usually deals with a specific set of facts for which it lays down specific consequences. This rule may define theft or murder and then lay down a penalty. In the form of principles. Principles are general pointers designed to ensure the fairness in the administration of justice. They are broader and more vaguely formulated than rulers and are often subject to far-reaching exception. A principle does not address a specific situation. A number of rules may be derived from principles in the form of policies, in the form of principles, in the form of the rules. The process of law is also sometimes guided by policy, which may be defined as a standard of decision making in the achievement of some determined social, economical, ideological goal. The principles of policy state in the Constitution, norms, and the scheming, customs, and community conventions. Custom and community convention also play a role in the life of the law, and they influence the decisions of the judges, whether constitutionally or unconstitutionally. Once recognized by courts by the legislature, such as customs and convention occur the force of law. Concretizations are the applications of norms. Related close to this step, this strictures of norms is the process of concretization and individualization. By concretizations of norms, we mean it is application to actual situation through the concrete judgment that solve the individual problem. This legal system does not consist merely in the recognition and promulgations of rules, principles, and other norms to form the structures of law. A process of concretization, individualization takes place in the application, implementation, and enforcement of legal norms. A rule providing that person guilty of breach of contract shall be liable in damages may become a source for concrete judicial decision. Ordering a to pay sum of money to understand the law properly, the student must see how concretion of the normative structure takes place in the daily work of the courts. Law enforcement agencies and administrative organs, in doing so, his case must move back and forth between the rule, part of the law, and the executions of the rules in the work of the courts and other law-related agencies. The normative and the factual side of legal system. As I said, the legal system is the combinations of generalized norms and the application and enforcement of these norms to concrete situations. This implies the legal system's the normative as well as factual side. The normative structure may be said to constitute an agreement, or in the sense that norms demand the compliances but are not only observed or carried out in the actual life. The normative and factual aspect of legal order interact closely with one another. There should be no legal system in any meaningful sense of the term in the absence of either of these elements. If the arts contain the norms remain on paper, don't influence human behavior, law becomes a myth rather than a reality. For the other hand, neither private person nor office of the government are guided in their action by any rules, principles, maxims of socially desirable conduct. Then arbitrariness and tyranny rather than law becomes a thinking force in society. This existence always sufficient degree of observance of norms and indispensable for the rule of law in society. This leads us to functions of law in society before this. However, we have redressed the issues of questions of law and fact in the territorial natures of the justice. Law and fact. The term questions of law or question of fact possess a more than a meaning. The term questions of law is used in three distinct yet related. The question that court is bound to answer occurs the rule of law. This is a question that law itself has answered. Whether the holder of the bill of exchange is guilty of unreasonable delay in giving notice of dishonor, questions of law. Whether contract delay building a house is a question of fact. A question of law is a question as to what the law is. Such a question arises out of uncertainty of law. Modern scholar calls such a law as hard cases. The third division is that questions of law are for the judges and the questions of fact for the jury. This applies jurisdiction where jury system is still in a vacuum. The term question of fact has more than one meaning or two. All questions that are not question of law are question of fact. This says question not falling in three above points listed for question of law or questions of fact. Another is between the what is right and what is fact. Facts are subject to proof. What is right depend upon the argument is a matter of judicial discretion. Another distance between opinions and facts is to be proved, while opinion cannot be proved or disproved. A distance also drawn up between primary and secondary fact. Primary facts are proved by oral testimony, documentary. Second fact are from primary fact. In the development legal system there has been trained to convert question of fact to question of law, establish authoritative and predetermined answer to many questions.